All right, let's talk Reg A. First topic of the day, especially now with things starting to go live. Start with introductions. My name is Scott Purcell. I'm CEO of Fund America Technologies. We are a company comprised of three parts: parent company Fund America Technologies, then a Fund America Securities, which is our clearing firm. It's a broker-dealer. Fund America Stock Transfer, which is our registered transfer agent. And collectively, we provide services to broker-dealers, to funding platforms like Start Engine and like Crowdfunder and others, and to large direct issuers, primarily large funds, with their 506 offerings, and recently with the Reg A offerings. We're also one of the founding members of CFPA, and I am on the board of CIFRA, and have written a lot of industry things along with Chris Terrell and Kim and Sarah and others in the room. On the Reg A front, about a week and a half ago, thanks in no small part to Doug Ellenoff and his team, we got the very first 5110 out of FINRA and went live with the industry's first Reg A offering for Elio Motors, which has been quiet until the last couple of days. But happy to say, I'm not at liberty to give any specific numbers, but they have already attracted in the first week many thousands of investors. They have more than met the minimum for the offering. So the good news is that the industry's first live Reg A offering is a success and will continue to be so. We got the second 5110 out of FINRA on Friday afternoon. It got qualified by the SEC yesterday, and that is for a company called Sun Dental, which will be going live today or tomorrow. So that'll be the second one. So the Reg A offerings are starting to come out of the SEC and out of FINRA so that they can go live. So on the panel today, we're going to be talking about this, and let's start with Sebastian, introductions.
Thanks so much for having me today. Sam did more than kind introduction of me, so I'm not going to repeat that, but I do wanted to give kudos to the office, the staff in the Office of Small Business Policy. It's a relatively, maybe not relatively, a small staff. There's 6 of us working on a lot of stuff over the last year. Very bright, hardworking group of people, very committed to facilitating capital formation for small businesses. So I want to recognize them, and thanks for having me in the program. One last thing, the standard disclaimer: the views that I expressed today may not represent the views of the commission or any of the commissioners or the fellow members of the staff.
My name is Steve Sadler. I'm the CEO of Allegiancy. We're a commercial real estate investment management company, a fee-for-service provider to large real estate owners. And we are in the 8th inning of putting our offering through the SEC process, expecting to be qualified probably at the end of this month on a $30 million equity raise for our company.
Hi, good afternoon. Excuse me, I'm Darren Marble. I'm the CEO of CrowdFundX. We're a leading crowdfunding agency. We help our clients and issuers to plan and execute strategic equity crowdfunding campaigns. So we do all the creative and all the marketing, and we're honored to be promoting the Elio Motors campaign as well as Dave Brody's campaign for XCI Aircraft.
I'm Craig Dunlinger, CPA with crowdfundcpa.com, and Artesian CPA is my registered CPA firm. We're specialized in audits and reviews for Jobs Act offerings.
Great. Well, let's jump into it. For the panel, we've been warned not to geek out too much on regulatory acronyms, but to deliver practical things. And that primarily, I think, applies to Sebastian and myself.
I'll do my best.
But let's set the stage real quick. Title IV is not Title III, aka Reg A is not 4A6. Sorry to geek out all of a sudden.
Yeah, that was fast. It didn't last very long.
Sebastian, what's the difference between Title IV and Title III?
So I don't want to go into the rules just because we could spend a whole day talking about the rules. I think what's important for people to remember is our goal is to try to put different avenues for capital formation. Not every exemption, crowdfunding, Reg A, intrastate crowdfunding, not one single venue of capital formation would be ideal for every single company. So the goal of the rules out there is to give the companies that need the capital the opportunity to choose what's right for them. each of the different exemptions have a host of different requirements, and I think companies should think about it, talk to their counsels, decide which option is the best option for them to facilitate the capital formation at the specific stage that that company is in. Whether you call it Title II crowdfunding under Title III, whether you call it Reg A crowdfunding, whether you just call it crowdfunding. From our standpoint, it doesn't matter so long as you determine what's the best avenue for capital formation for you and you comply with the requirements of those rules.
Right. One of the questions that Dara wanted to put out was that commonly people have is, should you use an underwriter or should you go solo on this? And originally I thought Sam was on the panel and I tagged him for this, but I'll take it. Going solo versus using an underwriter, or let's just put it simply, using a broker-dealer. Do you have to use a broker-dealer or can you do it solo? Obviously with Title III, you can only do it through a registered platform that's an SEC firm and a FINRA member. With a Reg A, federal guidelines allow you to file privately, to use solicitation, and to go solo. However, state regulations, according to NASA, do not. So the reality is, with Reg A or Title III, ultimately, you can't go solo, you have to use a broker-dealer. You have to use a FINRA member firm. So no matter what you're doing, you're engaging a FINRA member firm, whether it's somebody like Fund America or any other broker-dealer, you're going to be working with them. So let's talk about getting ready. What does it mean to get ready for your Reg A? So you're going to file, you want to do this, you want to do your mini IPO. Craig, why don't you talk about things from an accounting perspective?
The biggest thing is getting the books in order, and this will apply across the board. Title III is a review requirement, Title IV is an audit requirement. At the end of the day, the financial statements have to look the exact same. It's just a different level of a test work that I'm doing to sign off on it. So, keeping good records, making sure that you are tracking your cap table, that's something that every company I've worked with in the space, has issues with, of making sure they're recording the proper accounting entries on that kind of things. So getting competent people in early in the company is important whenever you're going out with an SEC offering.
And how long does that take?
Completely depends on the size of the company. If it's a fresh company, it could be a matter of 2 weeks. More complex, it could be a couple-month process.
And Steve, as far as getting your company ready to do this, what have you had to go through? What does it mean to get your company ready?
Yeah, I'm not sure we're ready. I mean, ultimately, every time you think you've got it, there's something new that sort of slides in from one side or the other. So I think it's a very dynamic process. And one of the things that we have to all come to grips with is nobody really knows what the hell they're doing. And so at the end of the day, when you're in conversations with a broker-dealer or you're in conversations with your CPA, they've never done a Regulation A+ offering before and they're not certain. And so you have a certain level, or I think a relatively high level of uncertainty that you've got to get comfortable with. For me as an entrepreneur, that's not a big deal, but when I'm talking to the compliance officer at a broker-dealer or somebody on the phone at FINRA or one of my attorneys, their view of risk is very different. So I think for us the biggest part has been trying to line all of these pieces up and understand them from the get-go, and of course it didn't work. We misunderstood one part of the regulation or one part of the filing process, or we failed to think deep thoughts about how we're going to clear securities and get this offering through DTC, or any number of little pieces that can screw you up and slow you down. And you can, I learned in a conference call yesterday where my language got relatively colorful and my blood pressure went up, that there was a simple form that our attorneys, the Underwriters Council and our council, had not put together yet, that was a requirement for the SEC to greenlight the deal. So we couldn't get the effective vote from the SEC no matter what unless we had that form. And I was just aghast that my crack team had not put that thing together, a month ago.
Attorneys are still learning as well. This is new for everybody.
No, I think that's right. And I think the part of what's exciting about it is it's new for everybody. But one of the things that we have experienced that I'm relatively passionate about is we have, as as issuers, as vendors, as participants in this, we really need to remain focused, and we need to force our partners in these processes to remain focused on keeping the transaction costs down. The only way this thing works to help with its purpose of forming capital formation for small businesses, the only way that works is if we can push on all of the various transaction costs, and there are a lot of them, and they add up very quickly. And if you're frugal with your personal money or you're frugal with your company's money, it'll make you mad at all of the parasites that you're picking off your carcass as you go through the process. But we've got to do that. We have to keep fighting and pushing to have some standardization and simplification and establish, I think, an acceptable level of risk so that we're not doing a $10 million Regulation A+ offering the same way Google did a $1.6 billion IPO. And the natural tendency is for people to do this offering the way they did the last offering. And if the last offering wasn't a Reg A+, which it wasn't, they're probably looking to a full IPO, full listing as their standard. And I think that's a real risk.
Cool. Well, Darren, talk about what it means to get ready in terms of marketing. Your marketing agency or your PR firm or whoever should be involved early in the process. So before you're testing the waters, before you're going live, what are you doing as part of getting ready?
Sure, great question. So I'll start with a statement that I think is applicable for Title III and Title IV, which is that an exercise in equity crowdfunding is an exercise in digital marketing, period. And a lot of the lessons that we've seen learned in the rewards-based space are going to be relearned, maybe painfully so, in the equity space. And that is that the success or failure of your equity crowdfunding campaign is going to be based on how well you plan your marketing and how well you execute it. Just to give you a sense, and now granted we're focused on the higher end campaigns and Reg A, but we assigned a team of 8 people over 3 months to pull these campaigns off, from video production, graphic design, digital marketing, social marketing, influencer marketing, events marketing, and paid media. And we put together a 12-point marketing plan for any campaign. I think at the core, what we've seen work thus far for Reg A is you have to have a compelling story as a baseline. You can do all the marketing in the world, but if you cannot tell the story of your company in a way that's going to arouse an emotional response from your customers, who are now your prospective investors, you're going to have a challenge. And so these campaigns become an exercise in storytelling, and you need to tell the story in a way that gets people excited. And I think people are voting with passion, maybe more so than they are looking for a financial return in this space at the unaccredited level. And we highly recommend, if you're going to do these campaigns, that you put at least 2 months into the planning. Think about how you're going to reach an audience. And just to cut to the chase, I want to share a statistic, 1%. So I predict that if you have an amazing campaign, 1% of your page views to your campaign page, might be Start Engine, Seed Invest, some other platform, are going to convert to investors. So for every 100 page views you get, I think maybe, in a best case scenario, 1 out of 100 becomes an investor. And I also think that if you want to do a $20 million raise, and the average investment, let's say, is $4,000, you're going to need 5,000 investors. So at a 1% conversion, you have to get 500,000 page views. So this is a marketing question. How do you drive 500,000 eyeballs to your campaign page? And that's the question you've got to figure out.
But I think you get there's some hybrid stuff going on too, because in our offering, we're using W.R. Hambrecht as our lead underwriter, which is an established Wall Street IPO investment banking firm. And so for us, in addition to a hopefully well-coordinated and effective outreach via the digital marketing platform, we also have the old-fashioned telephone marketing platform where W.R. Hambrecht and a host of other broker-dealers are actually reaching out to their clients to talk about this offering. So I think there's both of those things going on. Clearly, if you have a sexy product like XTI or Elio Motors, you probably get more traction in the social media world than I mean, not that our company's not sexy, but real estate management is kind of hard for people to get really excited about. And so, we're trying to do both of those things, both create, a brand image and some traction in social media, but also utilize the existing network. And I'll tell you, there are a lot of broker dealers that do a really good job for their clients, and those are people that I think you would be wise not to ignore. Don't just write that off and think that the only way to get these things done is straight down the internet path.
Yeah, we're happy to make introductions to as well if people need introductions, because to a broker dealer, many of them like Hambrick are our customers. So we can dial those phone
It's just
numbers
a little bit of brown nosing. We've had a really good experience with the SEC. I mean, in our case, we did a $5 million Regulation A offering about 18 months ago, and we learned a lot. And part of that was because the SEC was helping guide us in the process. But in the second go round, I mean, it has been very crisp, and the comments we received from the SEC have been spot on. I thumped our lawyers for some really bad drafting on the last go-round because there were things that were conflicting in the document. And so I think there's a tendency, at least for me, maybe not other people, to view the regulators in these various players as hurdles on my path to success or to the finish line. And I think in our case, certainly so far anyway, the experience with the SEC has been very favorable.
But let me make one observation about the marketing, because I've seen this with XTI, I've seen it with Elio. One of the things that a lot of entrepreneurs fail at is, I'm an entrepreneur as well, we fall in love with our company and we don't see the forest for the trees, and a fresh set of eyes from a marketing guy can come in and say, yeah, but that's not why investors are going to care about your company. And so you need to tweak your messaging. And these guys have been brilliant at that, quite frankly. So let's talk about that regulatory process. So you've gotten your company ready, you've got your attorneys on board, you've filled things out, and you have now filed your Form 1A with the SEC and your Form 5110 with FINRA, which the 5110 is required within 1 day after filing your 1A. So these forms are now in. What happens behind the curtains? What do people not understand about the SEC and its processes?
So let's demystify the SEC process. So when Reg A rules were finalized, we took a step back in the Division of Corporation Finance to try to look at what the goals were going to be out of the review. And with respect to any review, eligibility to use the offering exemption is key. And with respect to Reg A specifically, you have some key thresholds, eligibility requirements for the issuers, the type of securities that you can issue, and also whether you're doing an offering on behalf of the company or on behalf of shareholders to provide liquidity to the shareholders. So in any review, those key eligibility requirements are going to be part of what the staff is looking at. But let's delve a little more and look at Tier 1. So in a Tier 1 review, the staff is going to be looking at these eligibility requirements that I noted. It's going to be looking generally at compliance with disclosure, and it's going to be looking at the fact that the company has financial statements that are not stale and they seem to comply with the rules. Now, there's three important considerations that the staff will keep in mind when they're doing a Tier 1 review. One, these are exempt offerings. This is not a registered IPO offering. So the staff will keep that in mind when it's trying to determine what level of comments to issue. Number two, Tier 1 offerings are relatively small offerings. So the comments will be catered to the fact that these are relatively small offerings. And three, for Tier 1 offerings, you do have state regulators also looking at the filing and providing comments. So one practical tidbit, if you are doing a Tier 1 offering, don't wait to start the discussion with the state regulators until you actually have finished with the SEC. We don't want to get ahead of ourselves, so the SEC is not going to qualify an offering until at least one state is ready to qualify the offering. So from a practical standpoint, if you are doing a Tier 1 offering and you're going to have to deal with the states, engage them at the same time you engage us. It's going to make the process a lot more efficient for everyone. So Tier 2 offerings. What is different in the review process for a Tier 2 offering than a Tier 1 offering? Well, of the 3 considerations that I mentioned for Tier 1, 2 of them are not present. We don't have state regulators reviewing the filing, and the offerings can be a lot larger. The offerings can go all the way up to $50 million. So what you'll see is the staff focusing on the same type of issues, eligibility, disclosure, financial statements, but the comments may be taking into consideration the fact that 2 of those aspects that we consider in a Tier 1 offering are not in a Tier 2 offering. With respect to FINRA, to the extent that you do have a participant that needs to clear compensation through FINRA, we will ask that you have the FINRA people you're working with contact the SEC and let them know once they clear that compensation arrangement. It's the same process that exists for an IPO offering. The same thing applies for a Reg A. So just make sure that they reach out to us once that process is completed. Final thing I wanted to say, these filings are assigned to one of 11 groups within the SEC that have industry expertise. Once you make the filing, you will know which group it has been assigned to. If you have any questions, on the SEC website under Division of Corporation Finance, contact us. You'll have a list of who the assistant director and the branch chief for those groups are. There's a phone number there. If you have questions, if you're uncertain about something, do reach out to them. There's a reason we put their names and phone numbers there, which is if you have a question, do reach out to them. So I think it's important to demystify the process, and I hope that I'm glad to hear feedback that the process has not been as painful as some thought it was going to be. And that's the goal here, try to come up with a process that works.
But one of the things that has been, I think, a pleasant surprise for us is that it really has been geared toward, let's call it a less sophisticated audience. In that, we have been encouraged to talk to our SEC examiner, who actually called me and said, one of the stupid drafting errors was the lawyers put the wrong phone number down for the CEO of the company, so they couldn't find us to talk to us. But we have had that kind of interchange, and I think it's important to recognize for everybody in the room, whether you're a service provider or an entrepreneur, there's a level of sophistication that somebody like Google or Facebook has on their team that is not present in most of these smaller companies, and so the process is a little bit more, I guess, it's experiential, and so the SEC, in my view anyway, has been very kind to us in that regard.
Yeah, the thing about the regulators, both the SEC and FINRA, they've been very engaged, very thoughtful about their responses. You have to remember, as regulatory agency, they're charged with enforcing the rules, dotting the I's, crossing the T's. As individuals, they get it. They have family members, they have friends who have small businesses that are trying to raise capital, that need to hire people that can't. So everybody's on the same page, even though they have their mission and they have to fulfill it. But it's not a hostile or adversarial relationship that some people might think it is. It's actually very proactive, and I think Sebastian's done a good job articulating that. Really quickly, we're bumping up against time. I want to hit one thing very fast and then take a couple of questions. Costs, just bullet points. Craig, what does it cost for the accounting side, roughly?
For Title IV, where you have more established companies, that can vary quite a bit, but most of them we're getting done for under $10,000. Say 6 to 8 is kind of the average. For a fresh shell company, those are more like a couple few grand. Title III, I think you'll see more of that stuff when that comes through, just on the cost perspective.
We spent $75,000 on audit services for our A+ offering, and I'm not sure we're done yet.
Darren,
Steve has a very complex company, though. I was involved with that one.
What's a reasonable budget for somebody? Break out how much reasonable for testing the waters, reasonable for lunch?
So, admittedly, we work at the high end for Reg A, but our fees range from $10,000 for a pure advisory engagement, where we will simply assemble the marketing plan, hand it off to the client, and their team will be responsible for executing that plan, to, on average, $150,000 for a full service campaign where we're managing the campaign or owning it A to Z. Our company does deals for cash, at cost, and back end or equity only. And we also have investors who, if the issuer has a fundamentally sound business, great product or service, but may not have the budget to pay us for one reason or another, we can take that opportunity to a group of select individuals who may consider sponsoring the marketing.
Okay. And I'm actually going to pick on Sarah for legal fees because she's XTI's counsel. What do people need to budget for legal fees to get through this process?
It really depends. I think the legal fees are going to vary. At the low end, if I can characterize CrowdCheck as being at the low end, for the earlier startup companies, we do a fixed fee of $40,000 soup to nuts, and that includes due diligence. But for a company that's a lot more, like Allegiancy, I think, looking at the numbers filed, you're talking about 200, 300, aren't you?
I think that's probably right. By the time we're done with underwriters counsel, issuers counsel, and various, surprise pieces that come up, I think we'll ultimately be about $200,000. So our engagement with our attorneys at Allegiancy was about a $85,000 or $100,000 engagement, and I think we'll be close to that. But then you do have other people involved.
Yeah, underwriters counsel can get expensive, which is why our fees do not depend on there being an underwriter.
Well, and a lot of times underwriters counsel, you have to recognize that there's an interesting relationship there. The underwriter is talking to his attorney while you pay the bill. And so there's a different dynamic in how much time they spend in conversation.
And then how much are the actual filing fees for the regulators for the 1A and the 5110?
For the SEC, there are 0 filing fees.
It's drifting at the state level.
Yeah, that's better. FINRA's going to run you about $5,000.
I just want to make a quick comment and maybe a plug to Sarah, but I think it's really important, the great thing about Title III and Title IV, issuers can now solicit to the general public. Anybody over 18 in the United States is a prospective investor in your business, and you can promote through social media, paid ads, which we take full advantage of. That said, you need to have good counsel and advisors to make sure that if you're marketing the campaign or you're hiring third party or us, that you're playing by the rules. And we've been fortunate enough to have Sarah review every marketing campaign we do, from the wireframe, which is the art and copy, to the copy for the Facebook ads, messages for email marketing. All those things need to be reviewed by someone, a professional such as Sarah, to make sure that you're within the guidelines and not saying things you shouldn't be saying.
Like invest in the next Facebook.
Yeah.
Like invest in the next Facebook.
All right, questions? Yeah.
Darren, this is for you. How important do you see database marketing particularly, being important as you go forward and you have companies that may not be as sexy as Elio Motors or XTI? They've got a good story, but they don't have a huge database of users to begin with.
Super important. And so there's multiple ways to do database marketing. One is to create that database yourself. And we did this for XTI, and we offered email marketing. We had a contest where you submit your name and email to win a prize, which was a flight with Jeff Pino in a P-51 in Colorado. We acquired about 5,000 emails. Certainly we also acquire emails and do paid email marketing as well. The gentleman who talked about the mobile SMS marketing, I'd love to talk with you. I think that's a fantastic way to promote campaigns. Everybody is on their text message. Everybody's on their phone. Whatever advice you've gotten, throw it out the window. Title III, Title IV, let's go all in. I think that's exactly how we need to be reaching people, is on their phones. And this is the marketer's perspective, but I think that's a fantastic way. So, end of the day, I think it's a multi-level marketing approach. There is no silver bullet. It's not email marketing, social media. It's everything put together.
Well, the other piece I'll mention, just I know we're out of time, but the other thing to remember is that your marketing today is not just to get your deal done. You've got secondary market issues you want to be aware of. You need a marketplace for that initial buyer who might, a year from now, want to sell a share. You need some other people interested. So brand building and marketing has a long-term impact that's very important as well.
All right, thanks, Sebastian. Thanks, panel. Appreciate it.